The billing alert arrived at 3:47 a.m. on a Tuesday, flagging an invoice discrepancy that would unravel 12 years of partnership trust. I'm Augustus Whitman, 42, environmental partner at one of Washington, D.C.'s most prestigious firms. For over a decade, I've built my reputation on precision. Every brief filed on time, every client consultation documented, every billable hour accounted for down to the minute. The firm's case management system had never questioned my entries before. The automated email sat in my inbox like a digital landmine. Billing anomaly detected. Client development account 4471ENV. I'd been awake since 2 a.m. preparing for the Morrison Industries environmental compliance hearing, so I clicked it immediately. The discrepancy report showed charges to my business development budget that I'd never authorized. 17 separate transactions over the past 6 months, each one carefully timed during my busiest case periods. Restaurant bills in Georgetown. Hotel charges in Manhattan. Conference registrations I'd never attended. The total, $23,847. My first instinct was system error. Our case management software had glitched before, cross-contaminating client codes or duplicating entries. But these charges were too specific, too strategically placed. Someone had accessed my development account with surgical precision. I pulled up the detailed logs. Each transaction bore my digital signature and partner authorization code. The timestamps showed approval during court appearances when I was physically standing before judges, arguing motions. Whoever did this knew my schedule intimately. The conference charges bothered me most. Northeast Environmental Law Summit, Boston. I'd never registered for that event, but according to the system I'd not only attended but had submitted a continuing education certificate for bar compliance. The certificate was filed under my bar number with a forged signature that looked disturbingly authentic. I cross-referenced the hotel charges with my calendar. March 15th. Charged for 2 nights at the Meridian Manhattan while I was in Seattle, depositing a key witness. April 8th. Georgetown restaurant bill for $340 during my daughter's school play. May 22nd. Another Boston hotel charge coinciding with my appearance before the D.C. Circuit Court of Appeals. Someone wasn't just stealing from my development budget. They were building a false professional history in my name, creating a paper trail of activities I'd never participated in. The implications hit me like a cold wave. This wasn't random theft. This was identity manipulation with surgical precision. I scrolled through months of entries, finding patterns within patterns. The perpetrator had avoided my major case deadlines but struck during routine hearings and client meetings. They understood my practice rhythms better than most partners. This required inside knowledge, system access, and intimate familiarity with environmental law conference circuits. The billing system showed one more detail that made my blood freeze. Each fraudulent entry had been approved by a secondary authorization code, a safeguard requiring partner-level verification. Someone with administrative privileges had been covering these tracks, ensuring the charges bypassed normal oversight protocols. My hands trembled slightly as I reached for my phone. In 12 years of partnership, I'd never called our managing partner at 4 a.m. But this wasn't just about money anymore. Someone inside our firm was systematically destroying my professional reputation while building their own shadow career. The phone rang twice before Mortimer Ashworth answered, his voice thick with sleep. "Augustus? What's wrong?" "We have a problem," I said, staring at the screen full of. "Someone's been using my credentials to build a fake professional profile, and they're still doing it." The emergency partner meeting convened at 6 a.m. in our main conference room. Mortimer Ashworth sat across from me, his usually immaculate appearance slightly disheveled from the early hour. Our IT director, Vivienne Blackwood, had arrived with a laptop and several printed reports. "Show me everything," Mortimer said, pouring coffee from the firm's silver service. I walked them through the billing anomalies, the forged signatures, the impossible timeline of my supposed activities. Vivienne's fingers flew across her keyboard, pulling up system logs and access records. "This is sophisticated," she quoted. said, studying the screen. Whoever did this understands our case management software intimately. They've been careful to avoid triggering automatic fraud alerts. Mortimer leaned. How long has this been happening? Based on what I've found, at least 8 months, possibly longer. I handed him the printed statements. They've been building a parallel professional identity, conference registrations, hotel stays, restaurant bills, all in my name, all during times when I can prove I was elsewhere. Vivienne pulled up another screen. The secondary authorization codes are the real problem. Each fraudulent charge required partner-level approval. Someone with administrative access has been systematically approving these transactions. Who has that level of access? Mortimer asked. All partners, obviously, plus our office manager, the accounting director, and who? Vivienne paused, checking her records. Our client intake specialist, Mortimer Caldwell. He was granted elevated privileges last year when we upgraded the billing system. I remembered Caldwell's promotion. He'd been with the firm for 3 years, starting as a paralegal before moving into client development. Ambitious, personable, always eager to take on additional responsibilities. We'd trusted him with sensitive client information and substantial autonomy in managing new business relationships. Pull his access logs, I said. Cross-reference them with the fraudulent charges. Vivienne's expression grew grim as she worked. Augustus, you need to see this. Caldwell accessed your billing profile 47 times in the past 6 months. Always after hours. Always on weekends. And look at this. He's been downloading your client contact lists, case summaries, even your personal calendar entries. The pieces fell into place with sickening clarity. Caldwell hadn't just been stealing money. He'd been harvesting my professional relationships, my case strategies, my entire business development network. Every client lunch I'd arranged, every conference I'd attended, every strategic partnership I'd built, he'd been documenting it all. There's more, Vivienne continued. He's been using your credentials to register for environmental law conferences across the country. Look at these email confirmations: Boston Environmental Summit, Chicago Clean Energy Forum, Seattle Water Rights Conference. He's been attending these events as you, networking with your contacts, building relationships under your name. Mortimer stood and walked to the window overlooking K Street. This isn't just theft. This is professional identity fraud on a massive scale. I thought about the strange phone calls I'd been receiving lately. Potential clients mentioning conversations I'd never had, referencing meetings that never occurred. I'd attributed it to confusion or miscommunication. Now I understood. They'd been talking to Caldwell, who'd been representing himself as me. We need to quantify the damage, I said. Financial, professional, reputational. Vivienne pulled up another report. The direct charges to your development account total $47,000. But that's just the beginning. He's been using your name to secure retainers from new clients, then redirecting those funds through shell consulting agreements. She showed us a series of transactions that made my stomach turn. Caldwell had been approaching my environmental law contacts, offering consulting services under my name, then funneling the payments through a network of fake companies. The sophistication was breathtaking. He'd created an entire shadow practice using my reputation as collateral. How much? Mortimer asked quietly. Based on what I can trace so far, approximately $180,000 over 8 months. But Augustus, there's something else. He's been submitting continuing education credits under your bar number. If the state bar discovers this, you could face disciplinary action for fraudulent CLE reporting. The room fell silent. Professional misconduct charges could my career, regardless of whether I was the actual perpetrator. Caldwell hadn't just been stealing money. He'd been systematically destroying my professional standing while building his own. We never missed a Monday partner sync in 12 years, I said, more to myself than to them. How did we miss this? Mortimer returned to his seat. Because we trusted him. He had legitimate reasons to access client information, billing systems, conference databases. He used our trust as cover for systematic fraud. Vivienne continued typing, her expression growing darker. There's more. He's been corresponding with your clients directly, offering services that compete with the firm's practice areas. Look at these emails. He's been positioning himself as an independent environmental consultant while still employed here. I read over her shoulder, recognizing client names from cases I'd worked for years. Caldwell had been carefully cultivating these relationships, presenting himself as a more cost-effective alternative to the firm's services. He'd been planning his exit strategy while systematically undermining my practice. He's scheduled to be in the office this morning, Mortimer said, checking his phone. Client intake meeting at 9 a.m. I looked at the spread across the conference table. Bank statements, access logs, forged documents, fraudulent registrations. 8 months of careful deception, $180,000 in stolen funds, and a professional reputation hanging in the balance. When he walks through that door, I said, we'll be ready. Caldwell arrived at 8:47 a.m., 13 minutes early as always. I watched from the conference room as he settled into his workstation, coffee in hand, reviewing what appeared to be client files. The normalcy of his routine felt surreal given what we'd discovered. Mortimer had positioned himself near the reception area. Vivienne remained in the conference room, monitoring Caldwell's computer activity through our network administrator access. We'd agreed to let him begin his scheduled client meeting before confronting him. We needed to document any additional fraudulent activity in real time. At 9:15 a.m., Caldwell's client arrived. Through the glass partition, I watched him conduct what appeared to be a standard intake consultation. But Vivienne's laptop showed a different story. He's accessing your client database, she whispered, pulling contact information for 3 of your major corporate accounts. And look, he's copying files to an external drive. The turbo was mounting in real time. Caldwell wasn't just maintaining his deception, he was accelerating it. The external drive suggested he was preparing for immediate departure, likely planning to take comprehensive client data with him. At 9:45 a.m., his client left. Mortimer gave me the signal. I walked to Caldwell's desk with measured steps. We need to talk. Conference room. Now. His expression shifted slightly, a micro-expression of concern quickly masked by professional composure. Of course. Let me just save this file. Leave it, I said. Vivienne will handle your computer. That's when he knew. The color drained from his face as he realized we'd been monitoring his activities. He followed me to the conference room where Mortimer was waiting with the folders arranged on the table. Sit down, Mortimer said. Caldwell remained standing. What's this about? I placed the bank statements in front of him. Explain these deposits. Explain why clients are paying Caldwell Environmental Consulting for services they believe they're purchasing from our firm. He glanced at the documents, then back at me. I can explain. Start with the $180,000, Vivienne said from her laptop, or the fraudulent CLE credits, or the client data you just copied to an external drive. Caldwell's shoulders sagged. The careful composure he'd maintained for 8 months finally cracked. It wasn't supposed to go this far. How far was it supposed to go? I asked. He sat down heavily. I was planning to start my own practice. I needed seed money, client relationships. You were always so busy with the big cases, I thought you wouldn't notice if I handled some of the smaller environmental consultations directly. Using my credentials, I said. Using my bar number. Using my reputation. I was going to pay it back. Once my practice was established, I was going to make everything right. Mortimer leaned. By stealing continuing education credits? By forging conference attendance records? That's not borrowing. That's systematic fraud. Caldwell looked at the spread across the table. What happens now? Now we call the police, I said. And the state bar. And the IRS. His face went white. The IRS? $180,000 in unreported income tends to get their attention, Vivienne said. Especially when it involves identity theft and professional misconduct. Within 2 hours, our conference room had transformed into a crime. Detective Morrison from the Metropolitan Police Department's Financial Crimes Unit took Caldwell's statement, while Vivienne provided digital. The external drive contained client files, contact databases, and detailed business plans for his competing practice. By noon, IRS Criminal Investigation Division had assigned Forensic Audit Director Amber Steele to the case. Her team arrived with warrants for Caldwell's financial records, computer equipment, and business documents. "Mr. Whitman," Director Steele said, "will need comprehensive documentation of all affected client accounts, billing discrepancies, and professional credentials that were compromised. This appears to be a complex case of identity theft combined with tax evasion." The next 3 weeks blurred together. Client meetings to explain the situation, Bar Association interviews, forensic accounting sessions, media inquiries that our public relations firm deflected. The firm's reputation hung in the balance while investigators unraveled 8 months of systematic deception. Caldwell was arrested on charges of identity theft, wire fraud, and tax evasion. His bail was set at $75,000. The State Bar opened a formal investigation into the fraudulent CLE credits, though they acknowledged I was the victim rather than the perpetrator. The hardest part was facing our clients. 3 major corporate accounts threatened to terminate their relationships with the firm. 2 smaller clients filed malpractice suits claiming they'd been deceived about who was handling their legal matters. "We're going to survive this," Mortimer said during our emergency partner meeting. "But we need to implement new oversight protocols immediately." We hired a cybersecurity firm to audit our systems, implemented dual authorization for all client communications, required monthly financial reconciliations for every attorney. The measures felt excessive, but trust, once broken, required systematic rebuilding. Vivienne proved invaluable during the recovery process. Her technical expertise helped investigators trace the full scope of Caldwell's activities. She also helped other attorneys in the firm understand how to protect themselves from similar schemes. "He was sophisticated," she explained to our staff during a mandatory security training session. "He understood our systems, our procedures, our trust relationships. That's what made him dangerous." 6 weeks after the initial discovery, Caldwell pleaded guilty to all charges. The plea agreement included full restitution of $180,000 plus penalties, 5 years of probation, and permanent disbarment from practicing law in any jurisdiction. Director Steele's investigation revealed the true scope of his operation. He'd been running similar schemes at 2 previous law firms, stealing approximately $340,000 total over 3 years. Our case provided the needed to prosecute those earlier crimes. "Your documentation made this case," she told me after the sentencing hearing. "Without your systematic approach to gathering, he might have continued this pattern indefinitely." The firm recovered financially within 4 months. Our malpractice insurance covered most client-related costs. The enhanced security measures actually improved our operational efficiency, but the psychological impact lingered longer. Trust within the office felt fragile. Partners questioned decisions that had previously been routine. Staff members seemed more guarded in their interactions. The casual collegiality that had defined our workplace culture required conscious effort to rebuild. I found myself working later hours, double-checking financial records that had previously required only cursory review. The paranoia was probably excessive, but it felt necessary. Caldwell had taught us that betrayal could hide behind the most mundane daily interactions. 3 months after his sentencing, I received a letter from Caldwell in federal prison. He apologized for the damage to my reputation and career. He claimed to understand the magnitude of his betrayal. He asked for forgiveness. I never responded. Some violations of trust don't deserve the courtesy of acknowledgement. The firm's reputation gradually recovered. New clients replaced those we'd lost. Media attention faded. But the experience had fundamentally changed how we operated. Security protocols that had seemed paranoid became standard practice. Trust became something that required verification. By winter, our revenue had returned to pre-scandal levels. The enhanced oversight systems had prevented 2 minor billing errors that might have become larger problems. The crisis had forced us to become more professional, more systematic, more careful. But late at night, reviewing case files in my office, I sometimes wondered what other betrayals might be hiding in plain sight. 18 months later, I stood in the conference room of my new practice in Alexandria. The morning sun cast long shadows across polished mahogany, as I reviewed quarterly reports with my 3 partners. We'd built something different here. Smaller, more selective, more secure. Augustus Whitman and Associates specialized in environmental compliance for mid-sized corporations. No massive class actions. No celebrity clients. No headlines. Just solid legal work with transparent billing and ironclad security protocols. Every financial transaction required dual authorization. Client intake involved background checks that would impress the FBI. Our case management system logged every keystroke, every document access, every billing entry. Trust but verify had become our unofficial motto. The Caldwell investigation had made me something of an expert on internal law firm fraud. I speak on panels about lawyer retaliation and identity theft. Bar associations invite me to discuss security protocols. Young attorneys seek advice about recognizing warning signs of workplace betrayal. Last month, a partner from a Chicago firm called about suspicious billing patterns in their corporate department. I walked them through the same systematic approach that had exposed Caldwell's scheme. They discovered their office manager had been inflating expenses for 2 years. The irony wasn't lost on me. Caldwell's betrayal had destroyed my trust in colleagues, but it had also given me tools to help others protect themselves. His crime had become my expertise. My new partners knew the full story before joining the practice. Vivienne Ashworth, our litigation specialist, had actually worked the prosecution side of a similar case in Baltimore. Mortimer Blackwood brought cybersecurity experience from his previous corporate counsel role. Our third partner, Vivian Hartwell, specialized in professional liability defense. We'd structured the firm to prevent the kind of isolation that had made Caldwell's scheme possible. No single person controlled client intake. No individual had unrestricted access to billing systems. Every major decision required consensus. The practice thrived within these constraints. Clients appreciated our transparency. Our systematic approach to case management actually improved efficiency. Security had become a competitive advantage rather than a burden. Sometimes former colleagues from the old firm visited. They reported that business had fully recovered. New security measures had prevented 3 potential problems in the past year. The culture remained more cautious, but also more professional. I never asked about Caldwell. His name didn't come up in conversation. Last week, I received a wedding invitation from Vivienne Pemberton, the paralegal who had first noticed the billing discrepancies. She'd finished law school and joined a public defender's office in Richmond. Her attention to detail had probably saved dozens of clients from wrongful convictions. The invitation reminded me that Caldwell's betrayal had revealed character in unexpected places. Some people had risen to meet the crisis. Others had retreated into self-protection. The experience had sorted colleagues into categories I hadn't previously recognized. My new office overlooked the Potomac River. On clear mornings, I could see the Washington Monument in the distance. The view reminded me of ambitions I'd once held. The prestigious partnerships, the high-profile cases, the recognition that came with working at a prominent firm. Those ambitions felt distant now, like memories from someone else's life. I'd traded prestige for peace of mind, headlines for honest work, recognition for respect. The phone rang less frequently here. The cases were smaller. The stakes were lower. But I slept better at night. At 5:30, I locked the office and walked to my car. The building was quiet. Security cameras monitored empty hallways. Motion sensors tracked my movement through the lobby. Every precaution we'd implemented felt necessary rather than excessive. Driving home through Alexandria's tree-lined streets, I thought about the attorney I'd been before Caldwell's betrayal. That person had trusted easily, delegated freely, assumed good intentions. That person had been naive in ways that now seemed dangerous. The attorney I'd become was more careful, more systematic, more suspicious, but also more effective at protecting clients, colleagues, and myself from the kind of betrayal that could destroy careers and lives. The transformation had been painful but necessary. Trust required verification. Security demanded vigilance. Professional relationships needed boundaries that I'd previously considered unnecessary. It was finally over, and the silence felt earned.